In 2017, U.S. Circuit Judge William H. Pryor Jr. was one of 3 finalists for the first Supreme Court vacancy filled by Donald Trump. On Monday, Pryor issued a sharp rebuke of Trump's former chief of staff in a landmark Jan. 6 case. It may also have undermined Trump's claims to presidential immunity in Trump's Jan. 6 federal trial. The decision comes as both Trump's immunity claim and another key issue related to Jan. 6 could head to a conservative-leaning Supreme Court, where Trump nominees would fill 3 of 9 vacancies. And it's a timely reminder of how dimly many Republican and Trump-nominated justices have a dim view of Trump and his allies' efforts to overturn the 2020 election. The 11th Circuit Court of Appeals on Monday rejected former Trump White House Chief of Staff Mark Meadows' effort to have his criminal case in Fulton County, GA, removed from federal court. The 3-judge panel unanimously rejected Meadows' claim. As notable as the author of the decision is, Pryor is such a conservative judge that Supreme Court prospects are even worse than Roe v. He appears to have been hurt by his hostile remarks about Wade and past support for states being able to ban gay sex, and what Meadows said about his actions. Pryor wrote that Meadows' efforts, not only because former officials failed remove the cases to federal court, but also because Meadows' political actions make his case eligible for removal. In making this claim, Pryor repeatedly touched on the idea that Meadows was trying to interfere with the election results, sometimes discussed as a claim. But other points lacked this caution. At one point he talked about federal executive interference in state election procedures. At another point, he described Meadows' behavior in Cobb County, GA, as an attempt to infiltrate a non-public signature matching audit. Pryor also concluded that Meadows' official duty does not include changing valid election results in favor of a particular candidate. You can read these sections as describing allegations against Meadows, rather than directly accusing Meadows of something. But Cobb County's process appears to be an election, citing interference in the election and Meadows' attempt to infiltrate. Perhaps most importantly, the resolution defines Georgia's election results as valid in their own words. It's an adjective that Trump has wrongly objected to this day, even though it doesn't seem strictly necessary in this context. Also potentially important in the decision is what it might say about Trump's presidential immunity claims in his federal election subversion case. Trump's lawyers have signaled they will defend Trump's immunity because his actions fall under Take Care Clause of Constitution, which states that a president's duty is to see to faithful execution of laws. But Meadows offers no legal authority for suggestion that the president's authority is expanded to evaluate conduct of state officials. Pryor wrote, "The